issue of terrorist financing. Among the witnesses, Treasury Undersecretary Jimmy Groulet, U.S. Attorney Robert Conrad, and the Executive Director of the Muslim Public Affairs Council. This is about 2.5 hours.
Good morning, ladies and gentlemen. The Judiciary Committee hearing will now commence on the subject of how to combat the financing of worldwide terrorism. With last night's passage by the United States Senate of Homeland Security, we have again signaled the determination of the United States government to fight terrorism worldwide. We face enormous threats, as it is well known from the cataclysmic events of September 11th. And the United States government is in pursuit of al-Qaeda around the world. Al-Qaeda cannot function unless it is well financed. There are other major terrorist organizations such as Hamas and Hezbollah, and there again it is a matter of financing. And the United States government has taken steps to deal with our allies, our friends, and some who are not our allies or friends to try to stop the financing of terrorism. And we will hear testimony today about what has been undertaken with a trip in the mid-October by a key federal official to Europe to talk to our European allies about stopping money laundering and stopping the financing of terrorism. We're going to hear testimony of a successful criminal prosecution involving Hamas. And we are zeroing in on Hezbollah and all other terrorist organizations. Our hearing today is going to focus on an issue which has not received much attention, if any, and that is the potential criminal liability of individuals who contribute to Hamas or any other terrorist organization where those organizations are involved in terrorism which result in the deaths of Americans. In 1986, Congress passed the Terrorist Prosecution Act, which makes it a federal offense to assault, maim, or murder an American citizen anywhere in the world. In 1984, the United States exercised what is so-called extraterritorial jurisdiction on hijackings and kidnappings. Customarily, a criminal prosecution is brought in the jurisdiction where the incident occurred. But there is international law and international support for extraterritorial jurisdiction where U.S. citizens are involved. And with the strafings of the Rome and Vienna airports in December of 1985, it was obvious that we needed new legislation, which I had introduced and became the Terrorist Prosecution Act of 1986. When Hamas attacked Hebrew University and killed 8 people, including 5 Americans recently, one of whom was a resident of Harrisburg, Pennsylvania, that those murders triggered the Terrorist Prosecution Act. And people who contribute to Hamas, with its being well known that Hamas is engaged in terrorist activities and well known that they engage in murders, including murders of American citizens, those individuals are subject to criminal prosecution as accessories before the fact of murder. And I think that message ought to be a loud and clear one, which I hope these hearings will emphasize. That where it is known that you have a terrorist organization, and that terrorist organization, like Hamas or Hezbollah or al-Qaeda or others, has a record for suicide bombings which result in killing of Americans, those contributors are liable as accessories before the fact. We have a distinguished array of witnesses today. We're going to proceed at this time to hear from the Honorable Robert Conrad, Jr., who is the United States Attorney for the Western District of North Carolina. Mr. Conrad was a successful prosecutor of 18 defendants for operating a Hezbollah terrorist funding cell in Charlotte, North Carolina. The indictments occurred before 9/11, but the case took on added significance as a result of what has happened on 9/11 and since. This case was the first trial of a, quote, material support to a designated terrorist organization, close quote, charged in the United States. Mr. Conrad, we compliment you on your work. We thank you for joining us, and we look forward to your testimony. As it is the practice of the Judiciary Committee, the opening statements will be timed at 5 minutes. We'd like you to stay to the extent possible within that time. I understand in Mr. Conrad's case there's a video presentation, so the exception in your case will prove the rule, Mr. Conrad.
Thank you, Senator, and thank you for inviting me here. And I'd like to thank you all as well for your sponsorship of the Homeland Security Bill, which passed last night and should be a great asset to our ability to fight terrorism. I have submitted for the record a summary of this PowerPoint presentation. With your permission, I'd like to get right into it.
Thank you very much. The full summary will be made a part of the record, and we look forward to your presentation.
Senator, this was a 4-year investigation. Took about 5 weeks to try, and I've condensed what I can into a few minutes here to present with you today. And at the outset, I would like to tell you and the public that this case was prosecuted by our first assistant, U.S. Attorney Ken Bell, and the cooperation that he was able to coordinate among law enforcement agencies is something that the department is proud of, and I think the American people should be proud of. The first slide here is just simply the badges of various law enforcement agencies who cooperated together in the pursuit of the Hezbollah terrorist cell in Charlotte. And it goes from the state and local level to the international level, and it stands for the proposition that it's amazing what can be accomplished when no one who cares who gets the credit. There were prosecutorial challenges in this case that we didn't face in other cases. The use of confidential sources is something that all criminal prosecutors deal with, but in this connection, the sources that we used, we had to protect their lives and the lives of their family, and so it influenced everything we did in the case, from charging decisions to the way we structured search warrants, and it was a significant prosecutorial challenge. Of course, we did utilize evidence obtained through the FISA Act, and it's amazing what kind of difference a day can make. Sitting here talking to you today, we now have a FISA structure that was unavailable to us when we started this investigation. And had we had then what we have now, I think we would have learned earlier and been more effective in our pursuit of Hezbollah in Charlotte. We also obtained great cooperation from the Canadian Intelligence Service. We learned that they had electronic surveillance of a Hezbollah procurement cell in Canada with ties to our group in Charlotte. And over time, we utilized evidence that they had obtained in their country. The SEPA Act provided for protections of classified information, and fortunately, by the time we got to trial, the information we relied upon at trial was declassified, but we were prepared to jump through the SEPA hoops for judges and defense attorneys and other witnesses who would have access to classified information. One of the most significant things about our prosecution is the RICO charges that we brought against this Hezbollah terrorist cell. It was the first time in my knowledge that a terrorist cell had been subject to the prosecution under the RICO Act. It did a number of things for us. It allowed us to call them what they were. That was a Hezbollah financing cell. It allowed us to pick up acts of illegality that were time-barred because of the length of time it took us to uncover the illegal activity. And it allowed us to show to a jury fundraising that dated back a number of years. Our theory was that this group came to the country illegally, stayed in the country illegally, stole illegally, and then gave proceeds of stolen funds to Hezbollah in the Middle East. And we could say all of that to a jury in Charlotte, North Carolina as a result of the RICO charges.
Conrad, where did they come from?
Beirut, Lebanon, and various, they came to the country, as I will lay out as we go, through various mechanisms.
And there were 18 defendants.
Yes, sir.
Were there others, co-conspirators or others involved in the plot, ancillary?
Of the 18, there were 6 that we ultimately charged with material support. And there were other associates of the 6 who had various levels of awareness of what was going on. The benefit of the RICO statute is we could charge the whole group as an association in fact and bring all 18 before the United States District Court.
So this large group came from Beirut, Lebanon.
Yes, sir.
In a calculated way, coming to North Carolina, engaging in cigarette smuggling, which was the gravamen of their profits.
Yes.
Accumulated millions of dollars and funded Hezbollah.
Yes, sir. You've succinctly summarized our case.
So you wonder on that kind of an operation from Beirut with that many people going to a town in North Carolina on that kind of a scheme and plot, how far-ranging their activities must be.
I believe that if there's a Hezbollah terrorist cell in Charlotte, which was proven beyond a reasonable doubt to the satisfaction of 12 jurors, then there are similar cells elsewhere. And I think this is a
You wouldn't
serious...
ordinarily expect Charlotte to be the focal point of Hezbollah activities, would you?
You would not. We were very surprised to find that out. Of course, the material support statute is a great tool in the federal prosecutor's arsenal. It allows us to not only dismantle a financial enterprise, but in this particular case, it allows us to seek heavy sentences for the criminal conduct involved. And it is being used, the material support charge we brought in Charlotte was the first material support charge that was ever tried to a jury in the country, and it is now being used in Buffalo, Detroit, Portland, and elsewhere. One of the advantages to the material support charge is that it, upon a finding of guilty and the application of the sentencing guidelines, there's a severe sentence that is applicable as a result of that charge. There were other significant legal hurdles that we encountered and dealt with, but let me move on a little bit to the facts. What you have pictured before you is JR's tobacco warehouse in Statesville, North Carolina. JR's warehouse is the largest wholesaler of tobacco products in North Carolina, and it was here that this case began. An off-duty Iredell County deputy sheriff noticed young men coming into this warehouse and buying bulk quantity of cigarettes with bags full of cash. And then he observed them putting those cigarettes into a van and heading north on I-77. Now, the only thing north of Statesville on I-77 is Mount Airy, the home of Andy Griffith, and a state line. And once that van crosses a state line, a federal felony is committed. And this deputy sheriff was alert enough to recognize this suspicious activity and contact his friends at the ATF. The ATF began a cigarette investigation as a result. Basically, the investigation began in July of '96, and the surveillance led to the identification of Lebanese cigarette smuggling organization. The nature of this case was that in North Carolina, cigarettes are taxed at a 50-cent per carton rate, and no tax stamp is applied to those purchases. In Detroit, Michigan, cigarette tax is $7.50 a carton. And so this provided the economic incentive to purchase bulk quantity cigarettes in North Carolina and smuggle them for resale in Michigan. Our evidence showed that these co-conspirators averaged about $13,000 per van load, that they made approximately 3 to 4 van trips to Michigan a week, And that all told, they purchased approximately $8 million worth of cigarettes and made a profit of between $1.5 and $2 million. Now, the difficulty with the case was that we were sitting in Statesville, North Carolina, a rural community. And any juror who sat on this case would have actually benefited from the illegal activity of these co-conspirators. They were, after all, paying retail sales tax on these purchases. The loss was in Michigan, where the tax there was avoided by this illegal activity. So there, at this point, was a real question as to the jury appeal of a case like this. What happened was, at about this time in the investigation, when charging decisions on the cigarette case were being made, that the FBI walked in with news that they had, through their intelligence investigations, discovered a Hezbollah terrorist cell. And they showed us a series of pictures that are represented here. And what was interesting about this is that each of these people pictured, who the FBI had identified as being involved in a terrorism financing cell, were also our cigarette smugglers. In this case, ceased to be about cigarettes and became about Hezbollah. But these were intelligence sources, not sources we could use in a criminal case without burning those sources. And so a criminal investigation began on Hezbollah. And you know, Senator, post 9/11, people tend to forget who Hezbollah is in the wake of the attention focused on al-Qaeda. But we didn't forget. Senator Graham of the Senate Intelligence Committee just last spring referred to Hezbollah, not al-Qaeda, as the A-team of terrorism. Referred to Imad Mania, in contrast to Osama bin Laden, said that Mania made Osama bin Laden look like a schoolboy. Hezbollah is responsible for the Marine barracks bombing in Beirut in 1983 that killed 241 Marines, 6 months after they blew up the embassy in Beirut. They're responsible for the skyjacking of TWA 847 and the shooting death of a United States Navy diver who was dropped on the tarmac. And they were responsible for the series of kidnappings in 1980, including Terry Anderson and the CIA station chief Buckley, who was tortured and murdered. This is the group that we were confronted with in Charlotte, North Carolina. One of the things we did...
And they continue to the present time, Mr. Conrad, to practice terrorism on the southern Lebanon border going into Israel.
Yes, sir.
And they're reputedly financed by Iran and assisted by Syria. So they're a very formidable force.
One of the things that we did in this investigation is we executed 18 search warrants of residents of the people we identified as being part of this RICO enterprise. And at the residence of Mohammed Hammoud, the main target of this investigation, we uncovered this video. And the scene you're about to see is from that video from the house of Mohammed Hammoud, and it depicts members of the martyr squad from Hezbollah taking an oath.
What is this a picture of, Mr. Conrad?
This is a video taken from the home of Mohammed Hammoud, and it depicts members of a martyr squad taking an oath. We don't know who took the video. We found it in the home of Mr. Hammoud. It depicts...
It was taken there not knowing that it would be subject to seizure and observation by law enforcement officials.
Yes, sir. And quoting from the trial testimony, the translator translated what you just heard from the Secretary General of Hezbollah saying, "We will answer the call and we will take an oath to detonate ourselves, to shake the grounds under our enemies, America and Israel." And then a group responds, "We'll answer to your call, Hezbollah. We'll answer to your call, Hezbollah."
And that occurred in North Carolina.
Yes, sir. A second video was seized with, again, the Secretary General of Hezbollah speaking to a crowd. And he is saying, "Death to America." And the crowd is repeating behind him, "Death to America and death to Israel." And the crowd replies, "Death to Israel."
Where did that scene occur, if you know?
It is our understanding that those were speeches given in Beirut, Lebanon, and found in the home of Mohammed Hammoud in Charlotte, North Carolina.
Thank you.
If I could speak briefly about the two main targets of the investigation, Mohammed Hammoud and Mohammed Atef Darwish, and Darwish's cousin, Ali Fayez Darwish. They came into the United States in 1992 through Venezuela. They bought fraudulent U.S. visas for $200. They landed at JFK, dropped the credentials in the trash can, and claimed asylum. Their reason for asylum was that they were being persecuted by Hezbollah. What happened after that is amazing. They were given a hearing date and released, never to appear again.
Were they granted asylum?
They never even applied for it after that. Mohammed Hammoud, 3 times, was denied a visa from Damascus. At trial, he was asked why he went to Damascus for a visa, indicated no special reason. He was cross-examined on the fact that he went to Damascus because Hezbollah had blown up the embassy in Beirut. This slide is a picture of several of the convicted defendants. Each of them engaged in marriage fraud to stay in the country. Some of them tried 3 times before it finally worked. Approximately 500 bank accounts, credit card accounts, and other financial accounts were examined via federal grand jury subpoena and federal search warrants. The number of aliases and fraudulent identities in this case was simply amazing. Mohammed Hammoud had 2 valid North Carolina driver's licenses, one in his name, one in an alias. He also obtained other financial identities by either purchasing or being given student accounts. People who had come to UNCC Charlotte or UNC Charlotte and other universities and gone back to Lebanon would leave their account identifications with Mohammed Hammoud, creating an adopted identity. His brother, Chawi Hammoud, had multiple identities, and what is very interesting is on the far right, there's a Social Security card and an employment authorization card in the name of Havin Shavitsky. And this name never came up in the investigation. And we had expert testimony at the trial that the fact that you would have an identification never used was perfect terrorist tradecraft, that you would have an identity, never use it, unless, of course, you had to. Saeed Harb, another co-defendant, had multiple credit cards and identities. In fact, he had a notebook of fraudulent identities. And his theory was that every 7 years, if you declare bankruptcy, every 7 years, your credit is cleaned and you can start over again. He had 7 sets of false identities, and his theory was to bust out credit cards, 1 identity per year, $150,000 or more tax-free, and then just put that aside, and 7 years later pick it up and use it again. We caught him in the 2nd year of that.
Is there any way for the credit card companies or law enforcement to track that and stop someone from these multiple identities?
I hope with the threat of terrorism and the significant role that identity theft and identity fraud plays in that threat, I hope that is a focused concentration of law enforcement throughout the country. It is in Charlotte, North Carolina. Simple slide. Of course, it's always nice when co-defendants take pictures of themselves with ill-gotten gains. We learned through the FBI that Saeed Harb, our cigarette smuggler and credit card con artist, was involved in Hezbollah procurement activity in Canada. And we began slowly to take baby steps with the intelligence service in Canada and acquired information from them over time. First, for search warrants, which enabled us to look for Hezbollah-related material. Second, for purposes of detention hearings, and ultimately for use at trial, where we convinced a federal district court judge in Charlotte to admit Canadian Intelligence Service summaries of intercepts as exceptions to the hearsay rule in the trial of this case. And here are a few of those intercepts. In the first one, the there are
What was the basis for the exception of the hearsay rule? That sounds like a pretty sophisticated ruling. Having tried a few of those cases myself.
It was twofold. One was the public records exception. Canadian Intelligence Service is actually a public agency whose stated purpose under law is to perform surveillance of this fashion, and we were successful in making that argument.
And what was the quality of the cooperation by the Canadians?
It was outstanding. Ultimately, slow at first, some degree of reluctance to share information with American prosecutors that maybe they hadn't shared with the RCMP in cases before, but their cooperation with us was outstanding. The second theory was past recollection recorded. We were prepared to bring down the operators of the surveillance equipment in light disguise to testify at trial that at one point, when these things were fresh on their minds, that they recorded it in the fashion that they did. And once the judge admitted that and was going to permit us to let them testify in light disguise, the defendant stipulated to the admissibility of these intercepts. One of the defendants, who is still a fugitive, is Mohammed Dabouk. Mohammed Dabouk is such a major player in the Hezbollah organizations that on 5 separate occasions, his application to be a martyr was rejected. Hezbollah is such a organized terrorist group that they actually have application forms for martyr duty. And Dabouk applied 5 times.
Application forms for martyrdom?
To be a martyr.
That's a special application?
Yes, sir. And he was rejected 5 times because of his significance to this organization.
What are they looking for? What are the qualifications to be a martyr?
I don't think there's a whole lot of qualifications to be a martyr.
Why was he turned down?
I think when you're qualified, they don't want you to be a martyr. He was such a significant player that they would rather get other people other than him to
Too
perform that
important to
role.
be a martyr.
Yes, sir.
But you say separate application forms?
Yes,
like
sir.
applying for a job or
Yes, sir.
applying to law school or medical school?
That's what our investigation revealed.
Do you have a copy of such an application? We'd like to put one on the record.
This was human source, intelligence source information to us.
Yeah.
But Dabouk remarked in this intercept that he did not care about anything and was committed to securing all the items for the brothers at any cost to avoid going to hell and to secure a place in heaven by so doing.
You might focus on that for just a minute, Mr. Conrad. The questions arise. I was asked yesterday as to whether our Homeland Security bill would deter al-Qaeda and whether the president's activities in Prague, the NATO meeting, would deter al-Qaeda. And I responded that al-Qaeda and Hezbollah and Hamas are motivated by deep religious views and are, as you have noted, searching for a place in heaven. I think it'd be useful if you'd expound on that just a little bit as to the kind of an enemy you're dealing with here and how ruthless and how dedicated and how determined they are.
I agree with that assessment of the seriousness of their motivation, and it's unlikely that the threat of criminal prosecution would deter their violent acts. However, I think a successful criminal prosecution would disrupt their organized violent activity.
And incarceration would disrupt their criminal activities.
Yes, sir. And that was our goal. This next intercept involved a communication from Mohammed Dabouk to Hassan Lakis, the head of procurement for Hezbollah. Dabouk tells Lakis that he's ready to do, near the last sentence, "I'm trying to do my best to do anything you want. So please, you must know that I'm ready to do anything you or the father want me to do, and I mean anything." The father, our intelligence sources confirmed to us, is Imad Muniyah, the most serious terrorist in the Hezbollah organization. This is a lengthy intercept, the significance of which is that Mohammed Dabouk, in the course of discussing life insurance, refers to a person who might, in a short period of time, go for a walk and never come back.
Mr. Trotter, you might explain why some part of the sheet is blacked out, the redactions, for those who are unfamiliar with FBI reports?
Yes, sir. This we have presented both at trial and before you today a declassified version of the intercepts that were shared with us both by the Canadian Intelligence Service and as a result of our FISA warrants. This next intercept is a conversation between a fugitive defendant and Mohammed Dabouk, in which they talk about Imad Mania. And Dabouk says he knew who Imad was. Amhaz inquired if Imad was working with the young men, believed a reference to Hezbollah members such as Lakis. Dabouk revealed that Imad was a whole story. And in the next intercept, just talking about Imad Mania was a terribly dangerous thing to say. Amhaz asked why Dabouk said what he said, and Dabouk answered, would anyone bring up Imad's name, possibly as being associated with Imad, here in Canada or in any other country and stay alive? Next, quickly on the next slides, our source information was telling us that one of the members of the Charlotte cell was going up to Canada to get false driver's license and false credit cards, and the method of transfer was that these false documents were put in a cigarette package. It was greatly appreciated by us when CSIS shared information with us and showed us a series of photographs of our defendant from Charlotte in Canada taking first a credit card out of a cigarette pack and then a driver's license. Amazing corroboration of the human intelligence information we were getting. Senator, here are some of the things charged in the indictment that were procured by this criminal activity and the subject of expert testimony in our case as to their dual nature use by a terrorist organization. Night vision devices, surveying equipment, global positioning systems, mine and metal detection, video equipment, advanced aircraft analysis and design software, computer equipment, stun guns, handheld radios and receivers, cellular phones, nitrogen cutters, which I understand are for cutting metal underwater, mining, drilling, and blasting equipment, military-style compasses, binoculars, naval equipment, radars, dog repellers, laser rangefinders, camera equipment. Senator, this is a picture of the main target, Mohammed Hammoud, who was only 19 when he entered the United States via Venezuela in 1992. We asked ourselves, how could this person maintain a leadership role in an organization like this? One of his main contacts is a Sheikh Abbas Haraki, who's the leader of Hezbollah for all of Beirut and much older than Mr. Hammoud. And this is a FISA intercept of a conversation between Mr. Haraki and Mr. Hammoud. If I could take a moment to play it for you. One of the things you will note is the affectionate tone between the two gentlemen. This is an intercept of a conversation in about May of 2000 as Israel is withdrawing from Lebanon.
What's on the screen so the record can pick it up.
This is a translation of a conversation between Mohammed Hammoud and Sheikh Abbas Haraki, the leader of Hezbollah for all of Beirut, in which they are congratulating each other on the withdrawal of Israel from Lebanon in May of 2000.
خبروني في مشاكل بمركب قلت بده يكون الشيخ عباس فوق وانا وصلت المشكله كيفك عيونك والله الحمد لله مبروك مبروك الله يبارك بعمرك يا رب الله يحفظك الله يحفظك.
I'll go quickly through some of these slides. I know I'm over time.
How much longer do you expect to be, Mr. Conrad?
A few minutes.
Thank you.
These were all additional intercepts of conversation between our group in Charlotte and others, letters or intercepts talking about the opportunity to provide material support to Hezbollah from the United States.
Any references beyond North Carolina?
No, sir, other than the fact that one of our individuals was working with a group in Canada and coordinating the procurement out of Canada as well. This is a still photo of Sheikh Haraki off a video seized from Hamoud's house with the Hezbollah flag on the podium. A series of receipts for material support to...
Speaking from Lebanon?
Yes, sir. Series of receipts from Lebanon for money sent to Hezbollah by members of our organization in Charlotte. So in conclusion, ultimately 25 individuals were charged with first cigarette trafficking and later RICO, wire fraud, marriage fraud, and ultimately material support. At the moment there are 5 fugitives, 4 of them charged with material support. And this is what we're dealing with, Senator. This is a home movie seized from Mohammed Hamoud's residence. It is a picture of his nephews in Lebanon. And the trial testimony revealed that these 2 nephews were encouraged by adults to tell who they were. And initially, the children are not very responsive, and they're slapped in the face and commanded, tell them who you are, tell them who you are. To which ultimately, the little boy in red there says, Hezbollah, age 3.
Start him at a very early age.
Yes, sir. This is a picture of defendant Mohammed Hamoud, age 15, at the Hezbollah Center with his AK standing next to a picture of the Ayatollah Khomeini.
Mr. Conrad, how do you combat that? How do you combat indoctrination for children and teenagers?
From the U.S. Attorney's perspective, you do what you can with the effects of that indoctrination wherever you can.
We have to start at a much earlier phase, and that's something that this committee is working on.
Senator, if I could just show you a few slides. This is defendant Mohammed Darwish, who brought in a family friend to say there was nothing Hezbollah related about this group. And when asked about this photograph, he identified Mohammed Darwish as his cousin. On cross, he was asked if Darwish was a member of any militia, and he said no, despite this picture. Second picture, they asked this witness who the person on the left was. And he said, my cousin, Mohammed Darwish. And the prosecutor, Ken Bell, said, holding a gun? And he said, yes, holding a gun, and it's a very big gun. But this did not trigger any response that there was militia activity by Darwish, nor this picture. His testimony was just a group of guys hanging out, nor that picture.
And these pictures were taken where?
They were taken in Lebanon and seized in Charlotte. These are the 2 principal defendants, Mohammed Hamoud and Mohammed Atef Darwish, in Charlotte, North Carolina. From the Washington Monument, in a place we never wanted to see them. We accomplished our goal of disrupting and dismantling a financing cell in Charlotte. Whether we did more is anybody's guess. Thank you, Senator.
Well, that's very impressive, Mr. Conrad. It speaks for itself. And it raises the immediate question, if this is going on in Charlotte, North Carolina, involving millions of dollars in smuggling on a plot coming out of Beirut, what's happening in other places in the United States? And this is a matter which requires very intensive investigation. What was the result of the trial?
The result of the investigation is that 18 people have pled or been found guilty.
Have they been sentenced?
They await sentencing in most every case. We anticipate,
What do the guidelines call for on?
with the material support charge and a 12-level enhancement under the guidelines, and also a criminal history category 6, which is triggered by this kind of conviction, the judge can throw away the keys. The statutory maximum, however, is only a 15-year statutory maximum, and that might be one thing that the Senate should look at.
I think we ought to reevaluate the sentencing there for tougher prison terms.
If the guidelines trigger a 30-year to life sentence, but a defendant can only get a 15-year sentence as a result of a statutory maximum, perhaps that is something for you to consider. In this case, we've boxcarred 40-some charges.
We'll take a look at that. That's the purpose of the hearing, to see if the penalties are adequate. Mr. Conrad, when you talk about people in Lebanon, you showed pictures of planning, conspiracy, incitement to violence. What action would you recommend as to those people? American citizens have been murdered as a result of Hezbollah activities. You had the Marine barracks, which you've already identified, in 1983. You had the man thrown out of the airplane on the tarmac, a most brutal killing in connection with hijacking. Could you give us some idea as to how many murders Hezbollah has been involved in involving Americans, United States citizens?
I think prior to 9/11, they were responsible for more murders of United States citizens than any other terrorist organization known to us.
And a good many of those occurred after 1986, so they'd be subject to the Terrorist Prosecution Act with jurisdiction attaching as of that date.
Yes, sir. And one of the hopefully significant things of this investigation, there are 4 people charged with material support who are fugitives. 1 in Canada, 3 we believe are living in Lebanon. We would love to bring those people someday before a court of justice in the United States.
Well, the United States is moving against al-Qaeda. Key people. You saw what happened in Yemen not too long ago with military action taken against al-Qaeda, the key figures. Would you recommend that for Hezbollah key figures outside the United States?
Yes, sir. And I hope that extradition efforts and other rendering efforts might someday be fruitful here.
It's pretty hard to extradite from Lebanon.
And Canada.
But it's possible to do other things in Lebanon.
Yes, sir. At the very least, the world has become a smaller place for those individuals.
You mentioned FISA, the Foreign Intelligence Surveillance Act. Have you had an opportunity to study the lengthy opinion of the appeals court that was handed down 2 days ago?
I'm not posing as an expert in that area, but I have read that decision.
Well, it's a very, very far-reaching case. It goes back and disagrees with circuit court opinions which had concluded that the primary purpose had to be intelligence gathering, and picked up the legislative history and noted the intertwining of foreign intelligence and criminal conduct. There have been concerns raised about the civil liberties point of view, which are legitimate concerns, and the court said you could not use the Foreign Intelligence Surveillance Act if there's only criminal activity, but if there is an intertwining, then law enforcement does have a little legitimate role. This committee is going to do some hearings on that. It's a a very, very important subject, and the courts had interpreted Foreign Intelligence Surveillance Act to say the primary purpose had to be intelligence gathering, and in the legislation last fall, the so-called Patriots Act, the Congress changed that to significant purpose, and the Justice Department has argued that if foreign intelligence gathering is significant, and the primary purpose can be law enforcement. The court didn't quite go quite that far. But I'd be interested in your views at a later date as to how the interpretation by the appellate court would have affected your work. That case may well end up yet in the Supreme Court.
Yes, sir.
Well, Mr. Conrad, we thank you for a very impressive job you've done here. To take criminal prosecution as complex as this from beginning to end, I know from my own experience how difficult it is, and it's a great result. And perhaps an even greater result is putting the American people on notice as to how far-reaching Hezbollah's tentacles are. If they go to Charlotte, North Carolina, watch out.
Thank you, Senator.
Thank you very much, Mr. Conrad. We turn now to our panel number two, Mr. James Garuli, Undersecretary for Enforcement, Department of the Treasury, and Mr. David Hoffhauser, General Counsel for the Department of the Treasury. Mr. Garuli traveled to Europe very recently, mid-October, to provide several European governments specific information on selective high-impact targets so that they could, quote, be designated terrorist financiers and have their assets blocked. Those involved reportedly were wealthy Saudis with assets in Europe who provided financial support to al-Qaeda, and that is a major problem about the Saudis financing al-Qaeda, something that has to be looked at very hard. And Mr. David Hoffhauser, a General Counsel to the Department of Treasury, and has a key role as chairman of the Interagency Task Force on Terrorist Financing, which comes under the ambit of the National Security Council. So you men are right in the center of high-level efforts to block terrorist funding. Mr. Garuli, I understand this is your first appearance to testify in a congressional hearing on these important subjects. We thank you for coming and look forward to your testimony.
Thank you. Thank you, Senator Specter, for holding this important hearing, and thank you for inviting me and my colleague, David Hoffhauser, who you stated is the General Counsel of the Department of the Treasury. I'd like to take a few minutes in my opening statement and discuss the actions that the Treasury Department has taken to identify, to disrupt, and dismantle the the financial networks that are supporting al-Qaeda and other terrorist groups. It is also a pleasure to be here today with the United States Attorney Conrad from the Western District of North Carolina. As you've heard, he has been involved in a very important, kind of cutting-edge terrorist-related case that involved extensive interagency, international cooperation. I'm particularly pleased with the contributions the Treasury law enforcement made, specifically the ATF and IRS-CI. I'd also like to thank you and this committee for the important work that you've done, the tools that you've given the Treasury Department in the form of the USA Patriot Act. We've been actively involved in implementing the regulations, publishing the regulations to implement the legislation, and then to actually utilize these important provisions. What distinguishes the Department of the Treasury and its operational law enforcement components is the Department's unique resources and extensive financial investigative expertise, and I want to emphasize their financial, which has been developed over decades. These resources come from many Treasury law enforcement agencies, including the Customs Service, the Secret Service, FinCEN, IRS-CI, the Office of Foreign Assets Control, and other important Treasury offices. The Treasury Department is also in a unique position to leverage its relationships with domestic and foreign financial institutions and foreign finance ministers against the war against in the war against terrorist financing. Treasury's focus is both systemic and financial. We are looking at systems, ways, and methods that terrorists use to raise and to move money globally, both through traditional financial systems, banks, but also through non-traditional mechanisms such as charities, hawalas, bulk cash smuggling, and we've seen in addition trade-based money laundering. We follow the money through these systems to identify targets, through public designations, the blocking actions that we've taken, regulations, and investigation. And through these means, we're able to cripple terrorist access to these formal and informal financing channels. Our strategy is comprehensive and it's long-term. The President has stated repeatedly that this is a long-term effort. He is committed to combating terrorism for the long term, not only in the form of al-Qaeda, but other terrorist groups that threaten freedom and democracy around the world. This strategy focuses on 7 areas. First, targeted intelligence gathering. Second, freezing of suspect assets. Third, law enforcement, investigative actions. Fourth, diplomatic efforts and outreach, if you will, quiet diplomacy. Fifth, smarter regulatory scrutiny. Sixth, outreach to the financial sector, looking for ways to establish important partnerships with the public sector, with the government and the private financial sector. And lastly, capacity building for other governments in the financial sectors to ensure that their regulatory systems are not vulnerable to money laundering and terrorist financing. Let me speak first to the value of the designation process. This is clearly the most visible and immediately effective tactic of our comprehensive strategy. This has been to designate and block the accounts of terrorists and those associated with financing terrorism. In fact, just yesterday, the United States designated the Benevolence International Foundation and 2 sister entities in Canada and Bosnia and submitted these names to the United Nations Sanction Committee for worldwide designation. So we're taking action to designate terrorist financiers and cut off their access to U.S. financial institutions, but at the same time work with the international community so that the international community can take action to cut off their access to foreign banks throughout the world. I believe that this effort to date has been a very successful effort. It has resulted in the designation of 250 terrorist-related individuals, terrorist financiers, and entities, and it has resulted in the blocking of over $113 million in terrorist-related funds globally. And that means that we have 113 million, Senator.
Of terrorist-related funds have been seized, blocked?
Have been blocked. The effect of this is that $113 million have been prevented from going to the hands of terrorists and terrorist organizations for use to finance future terrorist acts. Let me just make one last point. I realize that my time is short, but I think it's important to emphasize that the effectiveness of these designations cannot and should not be measured strictly by the number of terrorist-related designations and the amount of money blocked. I mean, obviously this is important, but it's not the principal goal and objective. More important than these numbers is the disruptive and the deterrent effect that the designation process has on the actual and potential terrorist financing networks. Specifically, these designations advance global interest in suppressing terrorist financing by the following, and then I will conclude. First, by shutting down the pipeline by which designated parties move money to support terrorism. Second, by informing third parties who may be unwittingly financing terrorist activity of their associations with supporters of terrorism. Third, by deterring undesignated parties that might otherwise be willing to finance terrorist activity. Next, by exposing terrorist financing money trails that may generate important investigative leads that will assist the U.S. government in identifying terrorist cells in this country and abroad. Fifth, by forcing terrorists to use more costly and informal means to move money and riskier means to move money. In essence, to move them out of their comfort zone and cause them to use less proven methods of moving money, such as bulk cash smuggling. And then lastly, by supporting our diplomatic effort to strengthen other countries' capacities to combat terrorist financing. And finally, let me just comment, for me, over the last year plus that I've been involved in this undertaking, what has surprised me the most is the extent to which charities are being used to raise money and to move money to support terrorist activities. To date, the U.S. government has designated 15 Islamic charities that are connected to terrorist financing, and we have blocked collectively, domestically and internationally, first internationally, approximately $20 million in terrorist-related funds, and domestically, a little over $8 million of terrorist-related funds. With respect to my trip, I would just add that I was in Europe last month. I visited 5 countries in 5 days. 3 of those countries represented important international financial centers. I visited Switzerland, Liechtenstein, and Luxembourg to meet not only with the finance ministers of those countries, but also to meet with the bankers' associations to talk to them about ways in which we can enhance our efforts and make it more difficult for terrorists to access foreign banks and move money. I also had an opportunity to travel to Copenhagen and to Stockholm. When I was in Copenhagen, my purpose there was to meet with the chair of the EU clearinghouse. The EU has a clearinghouse process that is similar, there are some significant differences, but similar to the U.S. process of designation of terrorist financiers and entities, and there the concern was how to make the EU process more agile, more efficient, more expeditious in terms of designating terrorist financiers by the EU. And then lastly, with my visit in Stockholm, it was to meet with the incoming president of FATF, the Financial Action Task Force, in June of 2003. Sweden will assume the presidency. We've been working very closely with that important multilateral organization to establish international standards against terrorist financing. So with that, again, let me thank you for this important hearing, and I'm happy to respond to any questions that you might have.
Thank you very much, Mr. Greeley. I will have some questions, but first I want to turn to Mr. David Offhauser, General Counsel to the Department of Treasury. Welcome, Mr. Offhauser. We look forward to your testimony.
Thank you, sir. I have a very brief statement if you'd like to hear it.
I would.
Okay. I've done a little less traveling than the Undersecretary, but I was in Cambridge, England on September 11th of 2001, and I was attending an international conference on money laundering, and it was populated by a lot of luminaries in the field, judges, chief judges, the head of Interpol, the head of Europol, and a few general counsels. And although it was a pretty sober affair, it was also an affair of some self-congratulation, because we had made over 2 decades of work on money laundering some advances on a pretty bedeviling problem, taxing problem. We had elaborate computer screens, we had predictive models, we had profiles of conduct, we had some captures, we had some indictments, we had some forfeitures, all suggesting that we were making some gain on a pretty tough issue. The disintegration of the World Trade Center silenced everybody in Cambridge. It was a crowd of 400 people who prided themselves on the badges that they wore. And like most of you in this room, time and time again, in an audience of 400, we watched the building fall. And the silence wasn't just a demonstration of the awfulness of what we were watching. What it was, I think, and I might be projecting here, but what I think it was also was a realization by the professionals in the world that chase and hunt money, that perhaps we had been looking at the world through the wrong end of a telescope, and that the priorities were changing before our eyes. And instead of the priority of worrying about illicit money being cleansed and finding a place for concealment and hiding, what we really had to turn to and focus on, perhaps had not properly focused on earlier in time, was trying to capture money, clean money, that was spirited around the world intended to kill. The next morning, they put me on a military jump seat and flew me home, and I thought that the Treasury Department, particularly the General Counsel of the Treasury Department, would do the orthodoxy, which is to make sure we collect our tax revenues, make sure we sell our bonds, and then ship all the money across the river to the Pentagon to conduct a war. But this is anything other than a common war, and it requires a pretty unorthodox way of going about things. It's actually shadow warfare, that's a term that we've heard, and the primary source of the stealth and the mobility of the conduct of the war is money. And it's money that fuels the enterprise of terror. It also happens to be, fortunately, its Achilles heel. It leaves a signature, an audit trail, and that audit trail proves, in my judgment, to be the best single means of identification and prevention and capture. Indeed, and this was alluded to earlier by the testimony of the Undersecretary, much of the intelligence that we gather in this war is suspect. It's the product of treachery and deceit and interrogation and bribery and listening and trying to read encrypted talk. But books and records that are not intended for public oversight do not lie. They are literally the diaries of the enterprise of terror. Now, that's kind of a melodramatic statement, but I don't actually think it's possible to overstate the importance of the war campaign against terrorist financing. You can stop the killing if you can stop the flow of money. I also don't want to understate the difficulty of the chore. Ours is a deliberately open and porous economy, and the ways to game it are near infinite. Moreover, the problem is international in scope. The overwhelming bulk of the assets that we seek to freeze, the cash flow that we hope to slow, and the records that we hope to audit are beyond the oceans that surround us. To act alone would justly invite criticism. So once I returned to Washington, Secretary O'Neill and the Treasury team set about to craft an ambitious program of a campaign against terrorist financing, and it consists, as the Undersecretary has already stated, a number of steps. The first is an executive order that raises the standards of conduct and due diligence of financial intermediaries and explicitly targets even unwitting underwriters of terror for the seizure of their assets. The second is UN Security Council resolutions that mirror the same and criminalize terrorist financing. The third is more scrutiny at the gateways of the U.S. financial markets under the Patriot Act. The fourth is extensive public diplomacy to champion the need and the wisdom for international vigilance. The fifth is engagement of central bankers and finance ministers in the private pursuit of terrorist funds. And the sixth is outreach to the private sector for assistance in the identification, location, and apprehension of terrorists and their bankers. Much of that effort is overseen by a policy coordinating committee, which the Senator referred to, established by the National Security Council, which I chair. As best as humanly possible, although we all have feet of clay, as best as humanly possible, it's one government working in concert, sharing their intelligence resources to fight the campaign against terrorist financing. But the task remains unusually daunting. The material issues that face us include an insatiable appetite for actionable intelligence, which I know you know a great deal about, sir, increasing demands by coalition partners that we share the intelligence, and frankly, a chorus of competing voices that risks confusion of our message. As the Undersecretary said, this is not just a box score game. Only a small measure of the success in the campaign is counted in the dollars of frozen assets. The larger balance is found in the wariness and the caution and the apprehension of donors, in the renunciation abroad of any immunity for fiduciaries and financial intermediaries who in the past would have sought refuge in notions of benign neglect and professional discretion rather than in vigilance, in pipelines that we know that have gone dry, and in the flight to old ways of value transfer like gold bullion and precious gems rather than digitized electronic commerce, and the ability for us to focus our resources on those avenues of last resort for value transfer. And finally, in the gnawing awareness on the part of those who have banked terror in the past that the symmetry of the borderless war that they've declared now means that there is no place to hide the capital that they are underwriting terror with. I have one last point, with your permission. It's a short story, but I think it's pretty instructive of how we go about things. The Federal Reserve Bank in New York abuts the perimeter of the World Trade Center. It's an imposing and impregnable building, and it's the nerve center of the execution of U.S. monetary policy. It also literally houses the wealth of nations. Buried deep in the vaults of the New York Fed is the wealth of nations, $63 billion worth of gold reserves of hundreds of countries. It all had to be abandoned for the first and only time in history when the world...
You say $63 billion in gold reserves?
Yes, sir, in gold bullion reserves. It all had to be abandoned when the World Trade Center collapsed. The structural integrity of a third building, World Trade Center 7, was threatened by an inferno burning in the center of it. and the prospect of its toppling recommended evacuation for the New York Fed. Now, this was the first for the fortress-like Fed, as I told you. My counterpart, the general counsel up there, Tom Baxter, who's a member of my committee, by the way, sir, raced through the building, assuring himself that each and every one of his colleagues was out safely. Once satisfied, Tom prepared himself to descend the steps of that rather majestic building. There was a palpable sense of urgency. The World Trade Center was still smoldering, and there was the risk of the third building toppling. Police sirens were blaring, and the Fed's own police were urging Tom to run down the stairs. But first he turned to lock the door, only to recognize it doesn't lock from the outside. $63 billion of gold in an open building, and the last man out. So Tom hesitated. He thought of all the alternative ways of returning and winding his way through a maze of corridors and parking lot alleys to secure the building, but the entreaties of the police prevailed, and Tom joined them and was sped to a place of refuge where his colleagues were. When he arrived, he immediately telephoned Chairman Greenspan to report the good news that all employees were safe, out, and accounted for. The evacuation had gone without incident, and the chairman had only one question: Tom, did you lock the door? The answer, of course, was no. We did not lock the door, and we will not lock the door. If we do that to our financial markets, the bad guys win. So with perfect intelligence, we wouldn't need something like the Patriot Act. In that respect, it's a default mechanism, but a badly needed one, because we don't have perfect intelligence. Indeed, the predicate for everything we do is actionable intelligence, sir. I welcome the opportunity to discuss that with you, perhaps in another venue that doesn't jeopardize operations and sources and methods and the like, but I'll try to be as responsive as I can be this morning to any question you otherwise pose. Thank you, sir.
So the officials of the Fed just left and $63 billion in gold unsecured.
Well, actually, it's buried pretty deep in the bedrock of Manhattan, well below the subway system, and there is a safe.
Lucky these fellows from North Carolina didn't know about it.
Yes, sir.
How much would the $63 billion in gold weigh?
More than you and I can carry.
It wouldn't take a whole lot for that, but that's quite a story, and it's enormously serious, the work that you men are up to, and I'm glad to see what you are doing, and it shows areas where we have to be very, very vigilant. And Mr. Hoffhauser, when you commented about the donors and the apprehension of them and identification of the donors and discouraging the donors, I think is a very, very key point. Mr. Guruli talks about the charities at the outset of his testimony, and then he talks about 15 Islamic charities. And it is true that some of those charities have traditional charitable purposes in mind: to help people, help widows, orphans, help the destitute. But where the dollars are intermingled with funding terrorists, funding murderers, those donors have to be on notice that they are culpable, that they are liable, and that the jurisdiction of the United States attaches where U.S. citizens are murdered, and that people who make contributions, once they know, you have to have knowledge that there is a terrorist activity, and there has to be the assistance of that group. But that's pretty apparent from the history of Hezbollah, Hamas, and Al-Qaeda. But where these donors are put on notice that they could be liable for being accessories before the fact to murder, and an accessory is equally guilty with the principal under the law. That is the law of accessories. So that our quest here for the donors is very well placed and very well calibrated. Mr. Guruli, when you made your trip, and there may be some of this that you'd want to comment about in camera in a closed hearing, but the issue of the Saudis is a very, very big one. We have not yet come to grips with the bombing of Khobar Towers from 1996, where 19 U.S. military personnel died and 400 were wounded. The FBI was thwarted from questioning the people who were in custody. The 14 of the suicide bombers were Saudis. Osama bin Laden is a Saudi. There are public reports from our intelligence committees about the Saudis financing al-Qaeda. They do so under the representation that they are charitable, but that only goes so far. They know what al-Qaeda is doing. To what extent, if you can make a public disclosure, have your activities been directed to discouraging Saudi financing of al-Qaeda?
Well, I think we've made some important progress with the Saudis on this issue, on this problem of terrorist financing. And let me just illustrate with a couple of examples. In fact, in March of this year, the U.S. government and the Saudi Arabian government jointly designated a charity, an Islamic charity, by the name of Al-Haramain. This was the Somalia and the Bosnia-Herzegovina branches of Al-Haramain. So we jointly, public designation of these branches of this particular Saudi-based, by the way, Saudi-based charity, and these names were forwarded to the UN Security Council for addition to the UN list. As early as September of this year, the U.S. and Saudi Arabia jointly referred to the Sanctions Committee an individual by the name of Wael Julaydin, an associate of Osama bin Laden and a supporter of al-Qaeda, for designation and blocking. And perhaps even more importantly is the fact that we've been working very closely with the Saudis on ways to enhance oversight of Saudi-based charities. And one of the fruits, I think, of our joint actions has been an oversight committee that was recently established in Saudi Arabia, referred to as the Saudi Higher Authority for Relief and Charity. This is a committee that is making recommendations to the Crown Prince of Saudi Arabia on ways to better regulate, better control, and make more transparent these charities, so they're not vulnerable to abuse by terrorist financiers. And so the money is only going to support legitimate humanitarian efforts and activities, not terrorism-related activities.
How can that be accomplished, Mr. Grewley? If the money goes into the charity, who can supervise the disbursement of the funds to be sure that those monies do not go to terrorists?
I think that one of the ways that they're looking at doing this, and this again is based upon a recent meeting, in fact, yesterday, that David Offhauser and I held with the foreign policy advisor to the Crown Prince, where we discussed at some length this issue, and we're going to be engaged in further discussions. But they're looking at establishing an oversight agency that would audit these charities, conduct internal audits of these charities to determine, again, who the money's going to.
Who would those auditors be?
Well, they would be internal auditors within the Saudi government, part of this oversight agency that would be responsible for overseeing the activities and the transparency.
Would it be possible to structure some international participation there? I'd feel a lot more comfortable if the Saudis weren't auditing the Saudis. We've had some experience with auditors with conflicts of interest.
Certainly. No, I can appreciate that. Well, this is certainly something that we could raise with the Saudi government. I think it's important, though, nonetheless, to recognize the fact that the Saudi government is moving forward. They've recognized the problem. I think that they've acknowledged the problem, and they're taking, I think, important steps. They may be first steps, and there may be baby steps, but they're taking steps to address the problem, and they're working with us in that effort. So that's encouraging. Yeah.
Do your conversations with the Saudis include the issue of the Saudis financing Palestinian suicide terrorists, giving money to those individuals and their families?
That subject has been raised, and by the way, that subject has been raised in a broader scope with respect to our European allies as well. When I traveled to Europe in October, I raised at each of my stops and visits this issue that is a vexing issue for the U.S. government, and that is a distinction that is often made by European countries with respect to the military wing of Hamas, for example, and the political and the social wing of Hamas. And they are willing to take action against the military wing in terms of blocking and designations, but less willing, reluctant to take action against the social or the political wing. The U.S. government does not make that distinction. If the money is going to Hamas, we do not believe that there is a bank account for humanitarian activities and a bank account that is being maintained for terrorist activities.
Well, it is a distinction without a difference, the political wing and the military wing. The political wing has funds, and they co-join at a body, and those funds are made available to the military wing.
Well, we certainly believe that it supports the infrastructure of Hamas. It either directly or at least indirectly supports the activities of Hamas, including terrorist activities, and we're working with our allies to see if we can move them away from that distinction and to taking more aggressive action against supporters of Hamas and Hezbollah.
Well, if we come to the point where we proceed criminally against a contributor to Hamas for being an accessory to murder of the 5 Americans murdered at Hebrew University, and there's a defense, it went to the political wing and not to the military wing. I've had a fair amount of experience as a prosecuting attorney, a district attorney, and that kind of an argument doesn't have much credence with the jury. People better not try to defend themselves on the ground that they're dealing with the political wing and not the military wing when those funds are interchangeable. When you said you were successful on cutting off the funding for some $113 million, do you have any ballpark figure as to the extent of the money that is involved here? $113 million is a very impressive figure, but obviously there's a lot more. Is that the tip of the iceberg? Are we really dealing with funding into the billions?
It's difficult. It's very difficult to define the scope and magnitude of the problem with respect to the funds that are available to support terrorism. I think the fact that we have blocked, frozen, if you will, $113 million is significant, but I think it's even more significant that we have been able to cut off important channels of funding, and specifically financial networks like Al-Barakat. With respect to Al-Barakat, an organization that we believe has tentacles, if you will, that reach as many as 40 countries around the world. On the one hand, we blocked, when we designated Al-Barakat in the United States back in November of last year, we blocked approximately just a little over $1 million. But more importantly, we basically dismantled that network for moving money. And in the process, we cut off a channel that we believe had been moving as much as $20 million or more a year to support UBL and Al-Qaeda. So again, sometimes the money itself, the amount of money that's been blocked, does not tell the true story, the full story of the effect and the impact of our actions. But to be more direct and responsive to your question, I can't give you a precise figure as to the amount of money that's out there that's available as support.
We are dealing with large sums. If you
huge sums.
Intercepted $113 million, you can speculate or estimate it's many, many times that.
That's fair. I would agree.
Mr. Grewley, do you need any more legislation on the freezing of assets? Anything we can do for you here to start some legislation through to help you?
Well, the Patriot Act certainly
this is the right place to come.
Thank you. Thank you, and we appreciate your support. The Patriot Act has been very valuable, provided us some very valuable tools. And just recently, Deputy Secretary Ken Dam established a USA Patriot Act task force. This is a task force that Mr. Offhauser and I, as well as Undersecretary Taylor and Undersecretary Fisher, serve. It's chaired by the Deputy Secretary, and its purpose is to evaluate the effectiveness of the Patriot Act provisions and come back to Congress and ask for any amendments, any changes as we identify them.
Well, we're very interested in responding to your needs. It took us a little time to get the Homeland Security bill, but Senator Lieberman and I introduced it on October 11th, 1 month after 9/11, and it took too long, and it was touch and go up until the last minute. The House of Representatives last Wednesday passed a bill which was materially different from the bill that we had expected. And when you got to the fine print, many of us were very unhappy with a great deal of what was in the bill. And they say that you don't like to see either sausage or legislation made, but that bill bordered on giving sausage a bad name. It was a very tough matter.
Can I take you up on your offer?
Sure.
Give you some ideas?
I made it to you as well, Mr. Offhauser.
We actually have a bill up here right now. When we name a charity such as Benevolence or Global Relief or Holy Land as a terrorist organization under the executive order and IEPA, its 501c3 status continues in place, and it has the right. We have to go through a rather elaborate procedure at the IRS to revoke that license, and the revocation proceedings threaten to disclose important information. So we've asked Congress, and this has come through, it's been passed by the House, and I think it's, I must confess, I don't know if you're still in session today, but it's, if not this lame duck, if not this lame duck session, then in January, we've asked for a very simple amendment to the Internal Revenue Code, which would say that when we name a U.S. domestic charity as a terrorist organization, its 501c status is suspended and or revoked. So that's issue one, okay? So that's an automatic. Second, one of the powers that you granted the Treasury Department in particular under the Patriot Act is called Section 311, which is the power to designate persons or even jurisdictions, whole countries, as primary money laundering concerns. And there are severe consequences if they're named as such by the Secretary of Treasury. In those proceedings, we do not enjoy the same privileges of keeping classified information secret that we do in IEPA proceedings. So we'd like a parallel provision to protect evidence so that we can present it ex parte in camera in Section 311 proceedings that mirror what you all granted us in the Patriot Act with regard to the execution and the implementation of the International Emergency Economic Powers Act. And I can put that in writing to you, too. A third percolating thought, okay, because I heard your question about accessories to murder. We want to be clearly understood that we think those who bank terror are equally culpable to those who commit it.
Good.
That's point one. That's what the Undersecretary and I and the Secretary O'Neill are about on this mission on terrorist financing. Again, I meant it when I said if we stop the money, we stop the killing. Having said that, I think you know better than anyone, having prosecuted cases, and I know from defending cases with the likes of Brendan Sullivan and Edward Bennett Williams, that it's difficult for you to make a case for aiding and abetting in the absence of a knowing of specific intent of the actual injury that's worked. An idea that might be worth looking at by the committee and by your staff is borrowed from an area of law where I used to practice, which is public welfare offenses in the environmental area or in the food and drug area. And that's the notion of reckless endangerment, knowing and reckless endangerment. It's possible to get a serious felony for people who bank something like Hamas without having to demonstrate that they knew it was going to result, knew with certainty or beyond a reasonable doubt that it was going to result in the death of an American. So that's another idea that I think you could profit from looking at.
Well,
one last point, if I can, also on the Saudi issue. I want to be sure, and I know you didn't intend it, we are not at war with Islamic charities. In fact, we applaud them. It is important that what we do is not perceived incorrectly as having declared a campaign to undercut Islamic giving and Islamic charities. It's a tenet of their faith, as it is a tenet of most people's faiths, that charitable giving is a good and should be applauded. We have, however, declared war on counterfeit charities. And where it gets very, very difficult is that deliberate strategic decisions are made by terrorists to use a charity, frequently unwitting to the charity's fiduciaries, in a manner to divert money because of lax financial controls and the like, because the charities have outposts throughout the world in trouble spots, which are not well policed. And so when we talk to the Saudi government, for example, about more rigor in the audit and management of money that goes through charities, it is really an exploration with them of how to manage financial controls well so that money doesn't get diverted.
Well, I believe that it is indispensable, as you've noted, to make the distinction between what is really charitable work. And Islamic giving and Islamic charities are to be commended. And Islam is a great religion, and we have to avoid painting with a broad brush. We have to be very specific. But when the distinctions are made between a military wing and a political wing, that simply will not stand up.
We're in heated agreement with you on that.
Okay.
The idea that there's a firewall there is counterfeit.
So that has to be pursued. And for my work in chairing the Intelligence Committee in the 104th Congress back in 1995 and 1996, I have a lot of questions about the degree of cooperation of the Saudi officials. When I went and talked to the Crown Prince about Khobar Towers, it was a stone wall. And when FBI Director Louis Freeh went there on several occasions to question those suspects, and I've wondered whether those suspects were involved with Al-Qaeda and ultimately with 9/11. We did not have a chance to question them. There was a car bombing in Riyadh shortly before Khobar Towers was blown up. And I believe we have to press the Saudis much harder. We've got 5,000 of our military out there in the middle of a desert protecting Saudi Arabia. And we talk about cooperation by the Saudis in the movement by the UN as to Iraq. We're not getting it. So I think it is important to be very, very, very precise in what we're asking for and very demanding. We have to be fair. We have to acknowledge charities, but if it crosses the line, we've got to be very, very tough about it. I think your idea on reckless endangerment is a good idea. If at common law, if there's a reckless disregard for the safety of another resulting in death, that's the equivalent of malice, supports a prosecution for murder in the second degree. So you do not have to prove premeditation or the same level of criminal intent on reckless endangerment, and I think that's a good suggestion. It's good to have lawyers sit down and talk every now and then. Well, this has been very fruitful, Mr. Hoffhauser and Mr. Crewley. I thank you for what you are doing, and we will pursue the suggestions that you have made. And I think when you talk about the revocation of a 501c3, you're talking about something very different from detaining someone or denying someone liberty or having a search warrant or have seizing property. You're talking about really a privilege which is given, a benefit which is given. And the Treasury Department, the United States government can determine that. We don't have to exercise excessive largesse if there is reason to pull back. And tell that Pennsylvanian Secretary Paul O'Neill that we thank you for your good work. Thank him for his work.
Very much. Thank you, sir.
We'll now go to panel number 3. While panel 3 is being seated, I think it worth noting that other senators are not here today to participate in this hearing because late last night the Senate finished its business and we had a last vote on the continuing resolution. When the Senate concludes its voting, there are many plans. Many of my colleagues were in the air before 7 a.m. this morning, so that there is a lot of interest. And Senator Leahy, the chairman, and Senator Hatch, the ranking Republican, have statements which we will include without objection in the record. And Senator Leahy had asked me to chair this hearing, even though we do not have the same party designation, because of his agreement that the hearing was important and because of the work which I have done on the Judiciary Committee and in law enforcement reform. We had asked the Holy Land Foundation to attend and testify, to give other points of view, a hearing and an audience, but they declined, saying that they did not have adequate time to prepare once the notice of the hearing was given. So we will maintain an open record. If they wish to submit something for the record, or if they wish to be heard, we will give them an opportunity for a public hearing at a later time. Our first witness is a distinguished attorney, Mr. Nathan Lewin, who represents the family of David Boehm, a dual U.S. citizen, dual U.S. Israeli citizen, who was murdered by Hamas terrorists on a drive-by shooting in Israel. Mr. Lewin has instituted suit against a number of charities and has had considerable experience in the field, and we welcome you here, Mr. Lewin, and look forward to your testimony.
Thank you very much, Senator Specter. My name is Nathan Lewin. I'm a lawyer in private practice in Washington, D.C., in a family law firm called Lewin & Lewin that I operate with my daughter, Aliza Lewin, who's here with me today. I was a prosecutor with the Department of Justice many years ago, and I practiced white-collar criminal defense law and appellate litigation. I've represented former President Richard Nixon, Attorney General Ed Meese while he was Attorney General in an independent counsel proceeding, have argued 27 cases in the Supreme Court of the United States, and have taught at Harvard, the University of Chicago, Georgetown, Columbia, and George Washington University law schools. I'm gratified to have received your invitation to testify on the subject of the assessment of the tools needed to fight the financing of terrorism, because I believe I have discovered the cheapest means from the perspective of the American taxpayer to fight the financing of terrorism from sources within the United States. The principal tool for this battle is, I believe, America's private litigators, lawyers who are ready to bring private lawsuits at no taxpayer expense against private organizations and individuals who provide funds to organizations that engage in terrorist acts abroad or in the United States.
Excuse me one moment. We have people in the hall, people who have come in. You're welcome to come up front and have seats. There's no additional charge. And anybody who is in the hallway needing to stand in the hallway, I believe that you're all taxpayers, so we'll try to provide seating for you. You may proceed, Mr. Lewin.
I was saying, Senator Specter, that I thought this was the cheapest way from the American taxpayer perspective of deterring individuals and charities in the United States from supporting terrorism. I speak from personal experience. Sometime in 1997, when I was visiting the State of Israel, as I frequently do, I was introduced to Joyce and Stanley Boehm, the parents of David Boehm, a young man who was killed by Hamas terrorists in May 1996 when he was only 17 years old. David, who was born in the United States to American citizen parents, was standing at a bus stop near the school he attended when a car drove past and shot randomly at passengers boarding a bus and others standing nearby. The killers were two members of Hamas, the organization that immediately took credit for the attack. One of the killers went on to be a suicide bomber in September 1997 in the heart of Jerusalem, when he killed 7 others, including a young girl who was an American citizen, and wounded 192, including several young American students. The second, the driver of the car, is named Amjad Hinawi. He confessed when he was finally brought to trial in a court in the Palestinian Authority in early 1997. An American State Department representative, Mr. Abdel Nur Zeibek, witnessed the confession and reported on it. Hinawi received a slap on the wrist from the Palestinian court. Although he was found guilty and sentenced to 10 years of prison at hard labor, he has been seen walking around free in Palestinian territory. I testified about this outrage and the inexplicable failure of the Department of Justice to indict Hinawi and seek his extradition in a subcommittee proceeding chaired by you, Senator Specter, in March of 1999. Absolutely no progress has been made in the more than 3 years since that time. There's no reason in the world why a confessed murderer of an American student shot in cold blood while waiting at a bus stop has not been criminally charged by American authorities and brought to trial in an American court. I've met with the Department of Justice 3 times on this subject and have received no satisfactory explanation whatever. And there has not been a single criminal prosecution, Senator Specter, under the statute that you referred to, that I think you were involved in getting enacted, the Act of 1986, which makes this a criminal act that should be prosecuted by American authorities. Not a single person killed in Israel, American citizen killed in Israel, has been the subject, or none of the killers of those people have been the subject of an indictment in the United States court. The Boyms asked me then whether they had any remedy at all under American law. And I did what maybe too few lawyers do today, and I looked at the statute books. I found that in 1991 and 1992, Congress had passed anti-terrorism laws, including what is now 18 U.S.C. 2333, that gave American citizen victims of such terror anywhere in the world a civil remedy with treble damages and attorney's fees against those who commit murder or assault. Obviously, there was no purpose in suing Mr. Hinawi, who has no funds, if he can be found, and no funds that can be reached for a judgment. And his confederate killed himself and 7 others in a later suicide bombing. Against whom can such a statute be used? Over initial objections from my then partners, I drafted and filed a lawsuit against those who enabled the perpetrators to kill David Boym, the organizations in the United States that collected funds and provided other support for Hamas in the years preceding May 1996. I was challenged by my partners, by friends, other lawyers who wanted to know why I was suing the leading Muslim charity in the United States, the Holy Land Foundation for Relief and Development, and others that were engaged in purportedly charitable activities in the Middle East. I responded that the defendants in my case, none of whom are foreign governments or government agencies, knew that they were also funding violence by Hamas directed against civilians. I sued in federal district court in Chicago in the Northern District of Illinois because the United States had seized $1.4 million in a civil forfeiture action based on allegations of money laundering on behalf of Hamas. I hoped that the Boyms, who are the victims of Hamas terrorism, would be able to reach those funds. Our complaint was filed on May 12, 2000. On January 11, 2001, District Judge George Lindbergh denied motions by the Holy Land Foundation and other defendants to dismiss the complaint. I agreed to the defendants' request for an interlocutory appeal to the Court of Appeals for the Seventh Circuit because I believed it important that the litigation's deterrence to contributions for terrorism receive great prominence. Briefs were filed, and the case was set to be argued on September 25, 2001. And then came September 11th. The judges on the Court of Appeals, realizing the importance of the issues they were being asked to decide, asked the Department of Justice to file a friend of the court brief. We argued the case on September 25, and in November 2001, the Department of Justice filed its brief supporting my argument that any organization that contributes to a terrorist organization with knowledge that it engages in terrorism, is an aider and abettor of the terrorism, and is civilly liable for damages. The Court of Appeals accepted that argument in a landmark decision issued on June 5 of this year, which is called Boyne versus Quranic Literacy Institute, and is reported at 291 F. 3rd 1000. The Holy Land Foundation did not seek Supreme Court review, and we're now engaged in the discovery process. We're fortunate to have the volunteer assistance of a major Chicago litigation firm, Wildman, Harold, Allen, and Dixon of Chicago, and specifically Stephen Landis and Richard Hoffman of that firm in this time-intensive discovery stage. If not, we would not be able to continue with this exceedingly important lawsuit. And this brings me to my recommendations for legislative amendments that are essential to make this deterrent to the funding of terrorism work. First, although 18 U.S.C. 2333 provides for very substantial damage awards, treble damages, and attorney's fees, it does nothing to enable lawyers to pursue litigation prior to a final judgment. I and the firms I've been with since I began this project have invested approximately $1 million of attorney's time in this case. Although $1.4 million of seized funds is sitting in the clerk's office in the federal court in Chicago, we have received not one penny for the heretofore successful prosecution of this action. The law should provide that if a plaintiff is successful in defeating a motion to dismiss, he automatically recovers attorney's fees and out-of-pocket expenses from the defendants. That will enable the private attorneys general, such as myself and Mr. Gerson and the attorneys who are bringing his lawsuit, to continue to prosecute these cases to a successful conclusion. Otherwise, well-financed defendants can exhaust the plaintiff's lawyer in all the preliminary skirmishes that have marked this case. Second, funds that have been seized by the United States from defendants...
Mr. Lewin, you're about double time now. Could you sum up at this point?
I will. I'm just coming to a conclusion. My second point is that the funds that have been seized should be made available for the payment of plaintiffs' attorney's fees whenever the plaintiffs have prevailed at the pretrial stages. We sued the Holy Land Foundation. On December 4th, 2001, President Bush, Attorney General Ashcroft, and Secretary of Treasury O'Neill announced that they were seizing the assets of the Holy Land Foundation because it was used to support schools and indoctrinate children to grow into suicide bombers. Now, those seized funds are being used at a rapid rate to pay lawyers for the Holy Land Foundation for their work in challenging the seizure and in defending against our lawsuit. If the litigation goes on long enough, all the money that's been seized will be spent paying the lawyers to the Holy Land Foundation. They've lost their challenge to a seizure in a recent district court decision here in the District of Columbia, where the district court judge held that they had connections with Hamas, that they were actively involved with Hamas leaders, and that they provided financial support to the Hamas suicide bombers. Their lawyers are being paid top dollar from seized assets. Why should not the plaintiffs' lawyers also receive compensation for the work they've done? Third, the law should authorize the distribution and the availability of information that federal prosecutors gain in their investigations to the private attorney general. Prosecutors are loath to share information. There should be provision that grand jury and other investigative materials should be disclosed to private attorneys for their actions under court
Mr. Lewin,
order.
we have that point. Do you have any other specific points? Because we're going to have to move on.
Okay, then let me just say my two other proposals are that the statute of limitations be amended and that causes of action, that the theories that we've established in our litigation be specifically provided in the statute. Aiding and abetting, which you've spoken about, Senator Specter, should be specified in the statute as a basis for civil liability, and individual responsibility by individuals who contribute to these organizations. I thank the committee for the opportunity to testify here this morning and in this very, very important endeavor to cut off, as what the senator has called, and I think what everybody else has called, stopping the money, to stop the killing, to discourage the donors. I think that's the effort that should be made by the statutes. Thank you.
Well, thank you very much for your testimony, Mr. Lewin. I am very distressed that the Department of Justice has not acted under the Terrorist Prosecution Act. You noted the hearing we had 3 years ago, went into the case in some detail. You have performed extraordinary service not only to your clients but to America in pursuing this matter. And I'll have some questions for you when we move forward on the panel. Our next witness is distinguished lawyer Alan Gerson, co-counsel on a case filed by the September 11th victims against the financiers of Al-Qaeda. He was involved in representing Pan Am 103's victims' families and their claims against Libya. Very extensive experience in this field. Thank you for joining us, Professor Gerson, and we look forward to your testimony.
Thank you, Senator Specter. I am very appreciative of this opportunity to appear here today to contribute to the terribly important and urgent goal that this committee has set for itself, assessing the tools needed to fight the financing of terrorism. Surely, Senator Specter, the standard by which these tools can be assessed must in large measure revolve around the progress that has been made in securing for the families of the victims of 9/11 the rights guaranteed to them under recent U.S. anti-terrorism legislation. It is through these initiatives that they seek to hold accountable those responsible for facilitating the murders of their loved ones, and that begins with the proposition that the root of the problem lies in the financing of terrorism. First, I would like to express gratitude to you, Senator Specter, and the entire committee on behalf of the over 3,600 individual family members that Ron Motley, my partner in this endeavor, and I have the honor to represent. They understand that your continuing interest and involvement in the justice of their cause will enable them to play the important role carved out for them in the war against terrorism. Senator Specter, 9/11 was the work of terrorists that preach global jihad. The mass rallies of the Nazis, the fanning of bigotry and hatred, have now been replaced by the use of global jihad's adherents of the internet and the click of the computer mouse. And yet I fear, Senator Specter, that we are still using, and I will try to illustrate this in my remarks, antiquated and obsolete techniques and ideas to deal with today's threats. The victims of 9/11 were, of course, predominantly civilians. And yet today, these families, the families of the victims, have the capacity to strike back. But if, and only if, their hands are not tied. They must be allowed to invoke the full force of our laws. As Secretary of State Powell recently noted, the coalition against terrorism must advance on all fronts, political, financial, legal, and military, to root out terrorists wherever they live and plot. Indeed, President Bush, almost immediately following the September 11th attacks, proclaimed, "Our goal is to deny terrorists the money they need to carry out their plans. Our weapons are military and diplomatic, financial and legal." Today, the families of the 9/11 families are in the front ranks of those fighting the war on the financial and legal fronts. Their weapon is the legal process. Their principal target is terrorism's financial underbelly. And it is no accident that the organized 9/11 families call themselves Families United to Bankrupt Terrorism. For they are essentially acting through their lawyers, as Harvard's Professor Alan Dershowitz has characterized it, as private attorneys general, stepping in where the government is constrained by economic and political considerations. In this regard, our legal team has assembled highly experienced litigators to scour records in 13 countries on behalf of the suit we have filed entitled Burnett versus El Baraka Investment and Development Corporation and others here in the District Court for the District of Columbia. The suit names over 100 defendants in a complaint that spans 1,000 pages, with the third amended complaint to be filed this Friday. In addition, a more recently filed case in New York, Ashton versus Al-Qaeda, names many of the same defendants on behalf of approximately an additional 1,000 9/11 family members. The defendants in the Burnett suit are primarily Saudi banks, charities, institutions, wealthy contributors, and individuals some of whom have very close associations with the government of Saudi Arabia. In this effort, we have the active assistance of the governments of Russia, Uzbekistan, Israel, and Bosnia, to name but a few. We have the active cooperation of the Judiciary and the government's prosecutorial arms in Spain and in Germany. Indeed, in Germany, we are preparing, as I speak, to appear on behalf of the families as co-plaintiffs in a criminal prosecution against one of the alleged 9/11 plotters, a procedure permitted under German law. This will enable us to see evidence that is fresh, to call witnesses, and to strengthen our case. For example, one of the items obtained in our global investigatory efforts, and which will be noted in the third amended complaint, which we will be filing on Friday, is a document that shows fund transfers made by the Saudi American Bank located here in Washington's Watergate Hotel complex, payments made to the Middle East that ultimately ended up in Hamas's pockets for the purpose of suicide bombings in Israel. We intend to demonstrate that this financing pattern served as a template for funding al-Qaeda. We have also obtained judicial cooperation in tracking the al-Qaeda money trail that, as reported by the New York Times on September 21st of this year, ran from Saudi Arabia through Spain and directly to the perpetrators of 9/11. Senator Specter, for all of these reasons, I believe we are making good progress in using the tools that Congress has already made available to us. I am not here to ask for new legislation. Rather, I come to thank you for what the committee has made possible and to make one specific request. I respectfully urge you to do all in your power to make sure that those advances not be frustrated by pernicious maneuverings by those who persist in viewing the 9/11 family suit as unwarranted interference in America's foreign policy. Credible reports that our government might be considered stalling or otherwise impeding the suit were reported in the New York Times on October 25th, and as a result, a large delegation of family members promptly came by busloads from New York to stand vigil before the Capitol on November 1st to insist that our government stand with them and not against them. Regretfully, I am not in a position to assure the families that the cause for their great anxiety and fear of betrayal has passed. In a full-page open letter to the President that appeared in the Washington Post on November 1st, they asked that President Bush, quote, disavow any effort by our government to disarm us as we join you in the fight against terrorism, end quote. No response has been forthcoming. Today, recourse to the courts by American citizens against the perpetrators of terrorism is surely a constitutional right. It cannot be taken away or suspended without violating the due process and taking the property provisions of the Fifth Amendment. What is needed is an affirmative statement that there will be no interference in the 9/11 family's efforts to seek redress. Beyond that, I would hope that wherever practicable, there would be active cooperation in the sharing of evidence. Because, if I may conclude, it is in this context, a context of cooperation and sharing of documents between courts, involvement of private plaintiffs all along the way, making sure that evidence does not turn stale, and allowing them to go into areas where, for economic or other reasons, governments are loath to tread, that we have the essential elements of the new international public-private partnerships that are essential in enabling us to successfully wage the fight against terrorism. Thank you.
Thank you, Professor Gerson. The Congress has supported these claims with legislation on civil rights of action, and I do not believe that the executive branch will impede what you are doing. You may come to a point where you're seeking to attach assets of some foreign government where you may have some difficulties. Many of us on Capitol Hill have been supportive of you there as well, and we are available. We will monitor it all very closely, and we are available to be of assistance.
We enormously appreciate that expression of support, Senator Specter.
We turn now to Mr. Jonathan Weiner, former U.S. Deputy Assistant Secretary of State for International Law Enforcement, a member of the Council on Foreign Relations, and a member of the task force that recently published a report on terrorist financing. Thank you for joining us, Mr. Weiner, and we look forward to your testimony.
Thank you very much, Mr. Chairman. I'm grateful for the opportunity. Let's turn the mic on. Grateful for the opportunity to turn the mic on. There it is. Thank you
I can hear you, Mr. Weiner, but they might not on C-SPAN.
Thank you very much, Mr. Chairman. I am grateful for the opportunity to testify before you on the administration's use of the tools provided them to fight terrorism over the past year, and to discuss the findings of the report of the Independent Task Force on Terrorist Financing, sponsored by the Council on Foreign Relations and chaired by Maurice Greenberg. I've been working in the field of anti-money laundering for some 2 decades. And since September 11th, 2001, we have accomplished more in the past year than I thought would be achievable or achieved in my entire lifetime. Over the past year, the administration has undertaken a Herculean task, transforming the tools provided to it by the Congress and the Patriot Act into practical realities. By and large, they have done a remarkable job. As always, there are a few things that can still be done. In light of the discussion today, I'd like to turn directly to the charity issue. I think we still need to consider further action on Islamic charities, such as subjecting them to the Bank Secrecy Act. Some of these charities turn President Lincoln's quote on its head: "It's charity towards none and malice unto all." After I testified before the Senate last year, right after September 11th, one Islamic charity I listed on a chart as being alleged to have ties to terrorism gave me an ultimatum. I retract what I told the Senate, or they were going to sue me. On the very day they were planning on filing the lawsuit against me, the defamation action for my testimony, constitutionally protected testimony before the Congress, President Bush shut them down as a terrorist finance organization. You've heard about them earlier today. It was the Holy Land Foundation.
There you are, Professor Gerson. See the cooperation from the executive branch?
We welcome it.
That was the Holy Land Foundation that gave me that ultimatum. I'm tremendously concerned that funds from some of these charities have been used to purchase interests in otherwise legitimate U.S. businesses. I think that there is a penetration of other institutions that some of these charities have been able to engage in, and it's going to be tremendously important to investigate that and go after it. I've also seen that charity fraud and charity abuse is not limited to Islamic charities, as we've seen in the Washington area recently. I have encountered abuses of charities in many contexts during my time in government, both on the Hill and in the executive branch. Our regulation of charities at the federal level is minimal to non-existent, and charities are not today expressly covered by U.S. money laundering regulations. I would urge consideration of whether the administration should use its existing authorities to treat charities as financial institutions for the purposes of the Bank Secrecy Act, and thereby become subject to federal examination for compliance with our anti-money laundering laws. We're asking insurance companies and loan and finance companies to be subject to examination. We're asking hedge funds to be subject to examination, but not charities. Secondly, I would suggest that the Secretary of the Treasury should use his powers under Section 311 of the Patriot Act to designate foreign jurisdictions or financial institutions for special measures for enhanced scrutiny. This is a power the Congress gave the Secretary in the Patriot Act. The Treasury hasn't used the power. It is hard for me to understand that the Treasury has not identified even one foreign country or one financial institution that poses an unacceptable level of money laundering or terrorist finance risk, and therefore hasn't subjected a single one to the lesser level of sanctions available to the United States under Section 311. Mr. Aufhauser has asked for some additional protections in order for them to use the Section 311 authority. I can't assess whether the absence of those protections precludes such action, but I think action using that particular authority would send a very strong signal to financial institutions and other jurisdictions that we're going to protect ourselves. Third, I believe the U.S. government should be developing international standards for regulating and tracking gold and other precious metals and jewels that are used for transnational terrorist finance. The U.S. has had an exemplary investigation of money laundering through gold by Italian organized crime and Colombian drug traffickers in the Panama Free Zone. Dubai is the largest gold trading zone in the world. There really is more that we should be doing to try and create a standardized international global regulatory regime for tracking and regulating gold and other precious metals and gemstones subject to abuse, especially across borders. One means of doing it might be through the existing G8 anti-terrorist group led by Treasury. Fourth, you've heard quite a bit about problems for the private sector in the administration sharing information. I believe that in that connection, further information needs to be shared about our actions vis-a-vis hawaladars, alternative remittance systems. There is no location today where the public can go to determine whether a money transfer business has registered with the government, as they're all required to do under the Bank Secrecy Act and the Patriot Act. FinCEN has a confidential system for federal prosecutors to use. Not all of them know about it. I've talked to some who had no idea it existed, but they have such a system. The information is not public. I think it should be public, who's registered and who hasn't. It would have a lot of positive assistance for the financial institutions that don't want to do business with unregistered money service businesses. Lastly, and this relates to the information sharing issue as well, the private sector has to be brought in as a partner to governments in combating terrorist finance. British law enforcement has referred to the private sector as the deputy sheriffs, who've been deputized to assist the government in going after the bad guys and protecting us against them. I believe the U.S. could work with private sector institutions and non-governmental institutions to create white lists of financial institutions and perhaps charities that, regardless of the legal environment in their home jurisdiction, commit to the highest level of due diligence, anti-money laundering, and anti-terrorist finance procedures, and agree to a system of external assessment of compliance, precisely the idea, Mr. Chairman, that you raised in the Saudi context. External assessment for compliance is a critical element for such a white list. In addition to the reputational benefit from being included on such a white list, inclusion on the list could be a factor taken in consideration by the World Bank, the International Monetary Fund, and other IFIs in considering which financial institutions to put their money through, as well as by USAID and its counterparts in the rest of the world. Mr. Chairman, these suggestions have been endorsed by the distinguished bipartisan group of the Council of Foreign Relations in which I participated. I thank you for the opportunity to testify before you today.
Well, thank you very much, Mr. Weiner. We appreciate your being here. We now turn to Mr. Salam Al-Mariyati, Director of the Los Angeles-based Muslim Public Affairs Council, who authored an op-ed piece in the New York Times to the effect that Muslim charities should not be prosecuted, but rather officers of those charities if they support terrorism. We welcome you here and look forward to your point of view, sir.
Thank you. Thank you, Mr. Spector. I would like my full testimony in writing to be submitted for the record.
Without objection, your full testimony will be made a part of the record.
Thank you. And I'll keep my time limit to 5 minutes, so I'll keep my remarks very brief.
Thank you.
The Muslim Public Affairs Council has issued its counterterrorism policy position paper. In 1999, it presented it to the Clinton administration, and it has also submitted it to the Bush administration. In that paper, we talk about means of dealing with this problem of financing terrorism without shutting down charities at whole or making blanket indictments against charities. We believe that the effective way to combat terrorism, there must be a culture of understanding and cooperation among all Americans, between government officials and law enforcement on the one hand, and ordinary citizens and community on the other hand. Unfortunately, this tool of partnership is being threatened today. I'd like to talk a little bit about zakat, almsgiving, religious freedom, and national security. First, in terms of zakat, this is the religious obligation of every Muslim. It is one of the 5 pillars of Islam. It is similar to the Christian tradition of tithing. Zakat is a major manifestation of social justice in Islam. American Muslim charities make special appeals for the needy, whether in terms of feeding the homeless or in helping refugees abroad. American Muslims become very disturbed when reading reports that funds intended to uplift the downtrodden are used for violent purposes or are frozen under suspicion of being used for violent purposes. A very unfortunate climate has been created in which Muslims who donate money are being associated with nefarious activities. Just as it is wrong to associate all American Catholic charitable giving with the activities of the IRA, it is just as wrong to associate American Muslims giving with terrorism. Fundraising by American Muslim charities has been conducted in cooperation with and support from the local American Muslim communities and their mosques. If it is proven that directors of any institution were guilty of embezzlement of funds, then those individuals should be subjected to the full extent of the law, and they will be met with stiff opposition from American Muslims as well. The funds should either be returned to the donors or should be directed to the needy through legitimate non-governmental channels. If any wrongdoing is proven in an open court, government diversion of those funds for any purpose other than the donor's intent would be a misdirection of those funds a second time. The shutdown of American Muslim charities has detrimentally affected innocent people working or volunteering their time for the nonprofits. Incriminating innocent people results in tragic attack on the character of humanitarian activists throughout America. MPAC has argued that the U.S. Department of the Treasury should provide guidelines for meeting new anti-terrorism standards in order for American Muslim charities to demonstrate accountability in their fundraising and financial disbursements. We're encouraged that the Treasury Department has issued the voluntary best practices for U.S.-based charities. We have argued that the tools to combat terrorism are optimized in an open, democratic process, and preserving our democratic traditions in America is paramount for effectively combating terrorism. Short circuits to justice usually lead to a false sense of security. MPAC works with other groups to oppose the use of secret evidence in the courts, asks for open hearings, and protests indefinite detentions. In an ideal setting, American Muslim charities serve a national security interest by promoting a positive image of America throughout the Muslim world. Unfortunately, the view that American Muslims are a harassed or persecuted religious minority is gaining ground overseas, partially because of the blockage of the Muslim charities. Another important aspect of this problem is the issue of religious freedom, which the U.S. has championed in recent years, yet seems to be backtracking on as a result of new anti-terrorism standards. The United States risks being perceived as failing to adhere to the values we are promoting abroad. Lastly, Muslim charities which meet the urgent development and subsistence needs of many of the Muslim world's poor, dispossessed, and destitute can be used to enhance our national security interests by helping to mitigate some of the factors that breed extremism and violence. Thank you very much.
Well, thank you very much, Mr. Mariotti, for your testimony. Mr. Lewin, beginning with you in sequence of direct testimony, are the funds which have been frozen in the Holy Land Foundation available for disbursement to their attorneys?
Yes, they are.
How can that be if the funds are frozen?
Well, pursuant to the regulations of the Treasury Department, the funds that are frozen in proceedings to freeze those funds are made available to attorneys to defend in that case. In other words, the argument that's made is that as a constitutional matter, the organization that is being sued should be entitled to defend itself. And
no limitation, not even if those fees totally deplete the fund?
Well, there's no indication that there would be any limitation. I will tell you that in our case in Chicago, there's an attorney who is a very fine counsel. He comes up from New Mexico for every status conference in Chicago, is being paid out of that fund, even though our case is not the case in which those funds, the freezing of that funds is an issue. But nonetheless, because the funds may be used by counsel, to our knowledge, they are being distributed for his attorney's fees. And our concern is that this litigation may last long enough that by the time it's over, there'll be nothing left because the attorneys defending these cases will simply have depleted the funds.
Mr. Lewin, how do you propose to establish liability for the Holy Land Foundation?
We believe that it was public knowledge in the United States from newspapers well before 1996 that Hamas was engaged in violence, murder of civilians in Israel and in the Mideast. This was known through the media to everybody who ran the foundation and indeed to people who contributed to it. Therefore, we believe the foundation, when it contributed to Hamas, although they claimed they were trying, as I think had come out in prior testimony, to contribute only to its charitable activities, such as its hospitals.
Does the Holy Land Foundation have genuine charitable activities?
The Holy Land Foundation, I think, has genuine charitable activities. But the problem is that they also engage in financing terror, which is what the President and the Attorney General and the Secretary of Treasury found when they seized its funds. You don't have to show that the foundation or the organization is engaged exclusively in terrorist activities, but if they do so to a substantial degree by contributing to Hamas, which is what was found and what the district judge found to be true, then their funds may be seized and they are engaging in illegal funding of terrorism. And since they contributed to Hamas, and we believe that their own literature showed that they knew they were contributing to Hamas violence as well as to Hamas charities.
How do you prove that they knew they were contributing to Hamas violence?
Well, that's going to be proved, we think, by the fact that it was public knowledge that Hamas was engaged in violence and they contributed to Hamas, and B, it's going to be proved through discovery by the testimony of their officers who we will subject to examination on the question of what they knew about the people to whom they contributed, the organizations to which they contributed.
How do you deal, Mr. Lewin, with the considerations and contentions raised by Mr. al-Mariyati about freedom of religion and about the basic tenet, as Mr. al-Mariyati articulates it, for Islam to help on charitable goals?
Let me begin my answer by just a personal note. I don't think there's been any lawyer in the United States who has been more involved in trying to protect freedom of religion than I have. I've argued a number of cases in the Supreme Court under the Free Exercise Clause, and I am very concerned about that, both with regard to Jewish citizens and Muslims and Catholics and all minorities in the United States. I believe that freedom of religion can be protected by ensuring that the charities that collect for charitable purposes have internal guidelines which make sure that they disperse their funds only for peaceful charitable purposes. If they send it abroad, as the Holy Land Foundation did, they may not send it abroad to an organization that engages in violence.
Mr. al-Mariyati, would you accept that approach as a limitation on internal audits? That might not be too hard to accomplish if it would satisfy Mr. Lewin. What do you think?
Well, yes, and we're representing really not the charities themselves, but the donors. And the issue is if the charities don't fulfill their obligations by filing the proper tax forms or conduct the audits, then they are at fault, and the question is what to do with the money that the donors intended to give to the needy. That money should not be used for lawyers fighting battles out in court. That money should not be used for another country or another purpose altogether.
But how do you deal with the considerations which have been raised throughout this hearing about Hamas, for example, having a political wing and a military wing, and the funds can move from one to the other, so that a contributor may say, I want to give it to the charitable wing, but when you see what Hamas does at Hebrew University, is Mr. Lewin right or wrong when he talks about notice to the public as to what Hamas is really up to?
Well, I agree that if a group is on the foreign terrorist organization list, then any support financially for that group is a violation of the law, is a criminal act, and any person who conducts such a financial support for that group should be held liable. The charity itself should not be held liable. For example, if the United Way's chief executive officer commits fraud, the charity of the United Way should not be held liable. The donors to the United Way still want that money to go to the proper for the proper purposes. But the issue of what happens abroad, the Treasury guidelines is making it available for Muslim charities to demonstrate transparency, not only here in terms of the financial fundraising, but in terms of the financial disbursements over there. And I think by following those guidelines and by having an authentic accrediting agency then we can overcome this problem of intermingling of funds between legitimate charity needs and terrorist activity.
But the United Fund doesn't have a military wing.
No, I agree, but I'm talking about in terms of the problem of embezzlement and liability of the officer himself.
Well, embezzlement is always available as a criminal prosecution if some officer takes the money that belongs to the organization. But where you have an organization like Hamas, which is well known for the military wing, do you think it inappropriate to say to donors to Hamas, with what has been on the public record, that they're not knowingly contributing funds in a direction which will be used for murder?
Donors should be notified if that is the case. If the case is the money is going to a foreign terrorist organization, then donors should be notified and money should not go through those channels anymore. My argument is we believe as American Muslim donors, and I'm not here to support any foreign group. We don't take money from any foreign governments. I'm not here to even support the foreign governments that were made of issue today. But as donors, we believe that money can go to those in need in the West Bank and Gaza Strip without necessarily intermingling those funds with terrorist activities.
Mr. Weiner, when you talk about the regulations, should there be more regulations? Should there be federal legislation to deal with charities to try to make the dichotomy with Mr. Al-Mariati suggests?
First of all, I think that it would be useful for this committee to look, generally speaking, at the issue of regulation of charities and whether the current regulation of charities at the federal level, which is essentially an IRS matter, is sufficient.
What do you think? We're calling you as an expert here.
I think that no. Short answer is no.
Not sufficient.
Not sufficient. In that I have seen.
What more should we do?
There has to be some mechanism for examination and monitoring, at least of larger charities, certainly of larger charities that are operating internationally.
Examination and monitoring.
Yes.
Would you propose federal legislation to accomplish that?
What I would propose in the first instance is that the Patriot Act, which gives the Secretary of the Treasury the authority to designate certain kinds of institutions as susceptible to sufficient money laundering risk that they should be covered by the Patriot Act, should consider whether charities or certain types of charities should be required to be listed as financial institutions and thus be subject to examination in the same way we're subjecting insurance companies, for example.
So you think the Secretary of the Treasury has sufficient authority under the so-called Patriots Act?
Yes, sir, and under the Bank Secrecy Act, I do, sir.
Well, you've had a lot of experience with this, Mr. Weiner, with the Council on Foreign Relations. The committee would be interested in your views as to what supplemental legislation would be appropriate.
I will consider that further and respond.
Because that really is what we're looking at here, whether there ought to be more legislation. Mr. Lewin would like to have access to those funds before he gets a judgment. Thinks a motion to dismiss ought to be sufficient, and we'll entertain those thoughts. We can legislate on that. Professor Gerson, how are you going to collect from Al-Qaeda?
Well, our focus is not simply Al-Qaeda. Our focus is much, much broader than that. Our focus is...
You have a third amended complaint.
We have a third amended complaint with nearly...
Now, after your complaint, do you have a first amended complaint, and then a second amended complaint, and now you have a third amended complaint?
That's correct.
Your pleading file must be very thick.
It's enormous, and the reason it is enormous is because we have become, in effect, private attorneys general doing what the families of 9/11 have asked us to do, which is to focus on one issue.
How many
and
families?
that's accountability.
How many families do you represent?
We represent about 3,600 family members at this particular point. And we continue to represent more families every day, and they tell us repeatedly, it's well and good to listen to members of the administration. Some of them have testified today about new regulatory reforms that are going on, greater cooperation between the United States and the Saudis in this regard, the Saudi government. But we are interested in accountability because we want deterrence. We don't want a repetition of what occurred to our loved ones to happen to other loved ones, and that can't happen without accountability. So that's our focus. Are some of the families
whom you represent among those from Flight 93,
yes.
which crashed in Shanksville, Pennsylvania?
Yes.
Mm-hmm. How many do you represent there, if you know?
It's over a dozen. I'm not exactly sure.
We had a memorial service on September 11th this year, and the families were there, and it was a most moving situation where the families came from all over the country to visit the site where their loved ones had gone down in Flight 93, and very, very poignant and a tremendous need.
Well, out of this terrible tragedy, the families are trying to salvage something that will go beyond themselves and be a legacy to all Americans.
And you believe you have a realistic chance of identifying financial institutions where you can recover damages for 9/11?
Senator, I spent the last week in Spain working with the Spanish authorities under a special procedure that was authorized by Judge Robertson of the district court here.
Give me one illustration as to how you propose to establish liability and collect money from somebody.
Well, liability is established by using the standard that Attorney Nat Lewin referred to earlier in the landmark Boehm case. It is not incumbent upon us to prove that individuals that contributed to charities had actual knowledge of particular horrific acts that were going to be committed.
So you're looking to contributors to Al-Qaeda?
We are looking to the financial institutions that contributed part of their own revenues, sitting on their board of directors.
You've already filed this publicly. Can you name one financial institution? I'm trying to get a specific idea as to how you're proceeding.
I'll give you a list of the names of some of them.
No, just give me one and tell me what your approach is, your theory, how you're going to prove your case, and how you're going to collect the money.
Well, we are naming a number of organizations in Spain, for example, which goes beyond the focus strictly on Saudi-related institutions.
And you have jurisdiction in the United States.
We have jurisdiction
and service
in the United States, and we have already completed service on many of these banks. Many of the banks have financial holdings in the United States. The Saudis, for example, have on their own about $860 billion in the United States. We are intent on...
You're going after the Saudis.
Saudi interests. We have not named the government of Saudi Arabia as
Saudi
a defendant
interest. Name one Saudi interest, just so I have an idea.
Well, the Saudi, I mentioned earlier, the Saudi American Bank, which is located in the Watergate, will be named as a defendant.
Saudi American Bank.
Yes, they will be named as a defendant this Friday.
What did the Saudi American Bank and the Watergate do?
They served as a conduit for the transfer of funds to Hamas, we allege, and to Al-Qaeda.
Okay, and do you have to show knowledge on their part?
We have to satisfy the standard that the Seventh Circuit Court of Appeals spoke about in the Boehm case, which is not actual knowledge, but constructive knowledge, that is, that a reasonable person, understanding the circumstances, had reason to believe that this money was going to
Al-Qaeda and Hamas. Purposes. And if you can do that, of course, they know what Al-Qaeda and Hamas are up to.
Yes, of course.
Sure. Mm-hmm. Well, listen, thank you very much.
Could I just make one more point in response to the exchange you had here? Just a very
You make just one more point? Frankly, Mr. Lewin, I doubt that you could make only one point. But go ahead.
This one I promise.
You're free to comment even if it's more than 1 point.
All right. I think the analogy with regard to the Holy Land Foundation and the money being given to Hamas is as if the United Way Board of Disbursements, whoever the disbursement committee, said, we're going to give 15% to Murder Incorporated. Now, if they did that, then I think everybody would know that that's illegal and it's involved in murder. I don't understand why the Holy Land Foundation, if it says I'm giving some percent to Hamas formally, can say, well, okay, now as a charity, we're free of that. And I think that's what Mr. Mariotti is saying. The charity shouldn't be held responsible for the fact that it has given money to Murder Incorporated. That's what it's done.
Mr. Mariotti, you're entitled to respond.
Yes, thank you. Well, first of all, let's go to other examples. For example, you had the Jewish Defense League that targeted our office on December 17th. The FBI notified us. It was a group of Jewish terrorists who were involved in that activity. They killed Alex O'Day, allegedly, on 1985. The culprits have not been brought to justice. So those who supported the Jewish Defense League, are they going to be held with the same standard as American Muslims today are being held by in terms of supporting other charities? The IRA, and you mentioned the point about the distinction between the political wing and the military wing. In 1995, the Congress actually allowed Sinn Féin, the political wing of the IRA, to operate. I'm not saying that that's the road we need to take today because we live in a different era. But the point is, we have many Muslims in need throughout the world. And the hotspots involved in terms of charitable giving is going to involve the West Bank and Gaza Strip, Kashmir, Chechnya, Bosnia. Those are the areas where the front line of the war on terrorism is being fought. So we have to work more closely together with the government and with law enforcement, because I think there needs to be a paradigm shift where American Muslim charities are being used as a partner for national security abroad and for counterterrorism here, even domestically, in a more constructive way.
Mr. Weiner, you can have the last word.
Thank you, sir. It's a very bad thing when a witness, given an opportunity by a chairman of a committee like this, doesn't take advantage of it. So let me take advantage of your previous question. The committee
all the time.
The committee could consider the possibility of creating a receivership for any charity found to have had its legitimate funds commingled with terrorist funds, and appointment of a federal receiver. In that case, the federal receiver would then be in a position to be able to continue the legitimate activities of the charity while shutting down and stopping any potential leakage of that charity into illegitimate areas. Thank you, sir.
Well, thank you very much, gentlemen. I think it's been a very productive hearing. I admire what you are all doing. You, Mr. Lewin, and you, Professor Gerson, on tackling these matters as private attorneys general, very, very important. The government cannot maintain all these cases, and our courts are open to citizens, and that's why we legislated as we did, to give rights of action and treble damages and counsel fees, on the analogy to the antitrust field, because there's nothing like the lawyer. The lawyers are very frequently criticized, and I think very, very often unjustifiably, because cases are undertaken which are extremely difficult. They're undertaken without being on a retainer or without having an hourly rate which is paid. Very substantial costs have to be advanced, filing fees, deposition costs, travel. So you're to be commended for in the greatest tradition of the American legal profession. And Mr. Mariotti, we're very much concerned about the issues you raise on freedom of religion and about Islam religion on charitable matters and helping the needy. That's commendable. But we're going to have to draw the line. And I think Mr. Weiner may be able to help us with some practical suggestions from the Committee on Foreign Relations to draw that line. But this Judiciary Committee is going to be very active. And I've already given instructions, Mr. Lewin, to follow up on the hearing we had 3 years ago. Just not right that the Justice Department has not acted. I've discussed those matters with the Israeli Prime Minister Netanyahu, back in 1996, and Chairman Arafat. And there ought to be extradition. There definitely should be extradition. There ought to be teeth there. And we're available to legislate in the field. We appreciate your suggestions, and we're going to be pursuing this matter further so that people are on notice. We are dealing with Al-Qaeda or Hamas or Hezbollah, that when money goes there and it is known what the purposes are, that people can be responsible for accessories before the fact of murder, or as the suggestion was made, for reckless endangerment, which would not require the same specific intent but is equal to malice, which would support a prosecution for second-degree murder. So thank you all, and that concludes our hearing.
Thank you.
Yeah, thank you, sir.
What do you need? Come here again. Go get Terry.
And terrorist financing is among the issues we'll explore tomorrow morning on Washington Journal. Our guest will be Treasury Undersecretary Jimmy Groulet, who testified earlier in the hearing we just showed you.